You die tonight. Tomorrow morning, your house is still standing. Your savings are still in the bank. Your phone still buzzes on the kitchen table. And not one of those things knows who it belongs to now. So somebody has to decide. And if you never wrote it down, it will not be you. By the end of this video, you'll understand exactly who gets your stuff when there's no will, who gets absolutely nothing no matter how much they loved you, and the one thing about wills that most adults get completely backwards. 9 minutes, no jargon. Let's open the box. Picture everything you own as a room full of boxes. One box is the house, one is the car, one is the account with your salary in it. Small boxes, your grandmother's ring, the guitar, the shoebox of photos. Right now they're all blank, nothing written on them. A will is nothing more mystical than this. It's your handwriting on those boxes. This one goes to her. This one goes to him. That one, sell it, split it. That's it. That's the whole invention. A will is a pen. Now, here's the part nobody explains. If you don't write on the boxes don't just sit there forever. The government brings in its own label maker. Every country, and in the US, every single state, already has a default list written into law. It was written long before you were born. It doesn't know your name. It has never met your family. It doesn't know that you haven't spoken to your brother in 11 years, or that the person who drove you to every hospital appointment isn't technically related to you. It just works down a list of relatives in a fixed order and stamps. Lawyers call dying without a will dying intestate. Forget that word. Here's the honest translation. No will means you didn't fill in the form, so the state fills it in for you, using the answers of an average person who isn't you. So what's on the list? The exact order changes depending on where you live, but almost everywhere on Earth it's built out of the same 3 ideas, in the same rough order. Step 1, your spouse. If you're legally married, your husband or wife is usually at or near the top. Note the word legally. The paperwork matters here, not the relationship. Step 2, your children. In most places, the estate gets split between the spouse and the kids, and this surprises people. A lot of people assume the surviving spouse simply gets everything. Often they don't. Often they get a share, and the children get the rest, including a slice of the house. Sit with that one for a second. It means your widow or widower can end up owning part of a home, while your adult children own the other part. If everyone gets along, fine. If one child needs money and wants their share out of it, the house may have to be sold to pay them. That is not a rare horror story. That is just the default list, doing exactly what it was written to do. Step 3, everyone else in order. No spouse and no kids, it walks outward. Parents, then brothers and sisters, then nieces and nephews, then grandparents, cousins, and on down the family tree. And if it walks all the way to the end and finds nobody at all, in most places, everything you built goes to the government. Now the harder half. Because that list doesn't just decide who's in, it decides who's out. Look at who is standing behind the rope. Your partner, if you never married. 10 years together, same address, shared everything. In most places, the default list does not see them. It's looking for a marriage certificate, and there isn't one. They can be sitting in a home they helped pay for, with no legal claim to it. Your stepchildren, you raised them. You went to the school plays. If you never legally adopted them, the default list usually walks straight past them and hands your things to blood relatives instead. Your best friend, your carer, the neighbor who checked on you every single day. Nothing. The list doesn't have a step for the people who actually showed up. A charity you cared about your whole life. Nothing. Nobody on the list will give your money away on your behalf. And here's the thing to be clear about. This isn't the law being cruel. The law is doing the only thing it can do. It has no information. You had the information, you just never wrote it down. A will isn't really about who gets your things. It's about who doesn't get skipped. If you have children under 18, one line in a will matters more than every other line combined. Who raises them? That line is called naming a guardian. Without it, a court decides. A judge who has never met your kids, working from whatever relatives step forward and what they can prove. Family members can disagree. Sometimes they disagree in front of the children. You may have said 100 times, out loud, who you'd want. It was never written down, so it never officially existed. Now, the second thing nobody warns you about, the waiting room. Before anything gets handed to anybody, most estates go through a court process called probate. Someone has to be appointed, debts have to be paid, property has to be valued. With a clear will, probate is paperwork and patience. Without one, it's slower, because before the court can hand anything out, it first has to work out who's even entitled to it and appoint someone to run the whole thing. Months, sometimes well over a year. And while that clock runs, the bills on the house don't stop. That's the real cost of no will. Not just the wrong people getting your things. It's your family, in the worst month of their lives, standing in a queue. Now, the part that trips up almost everyone, including people who already have a will. Your will does not control most of your money. Some of the biggest things you own don't go through the will at all. They have their own instructions attached, written years ago, and those instructions win. Your life insurance, your retirement or pension account. In many places, accounts you own jointly with another person. Each of those has a beneficiary. A name you wrote on a form, probably on your first day at some job, in a room you barely remember. Whatever name is on that form gets the money. Even if your will says something completely different. Even if the will is newer. Even if the person named is an ex-partner you haven't spoken to in 15 years. That is not a loophole. That's how it's designed. And it's why people write a careful will, feel relieved, and still leave the largest check of their life to entirely the wrong person. So the real question isn't, do I have a will? It's this. Do the names on my forms still match my life? Two things. The first one is free and takes about 15 minutes. 1. Go and read your beneficiary forms. Log into your pension or retirement account and your life insurance. Find the beneficiary field. Look at the name. If it's blank, or it's an ex, or it's a parent who has since passed away, change it today. This is the single highest value 15 minutes in this entire video, and it costs nothing. 2. Write the will. For a straightforward situation, simple valid options exist almost everywhere, and they cost far less than people assume. If there's property, a business, children from more than one relationship, or anything crossing a border, that's when you pay a professional, and it's worth it. Then, if you have kids, put the guardian's name in it. And one small thing that costs nothing at all, tell one person where the will is. A perfect will that nobody can find does the same amount of good as no will. So one sentence to take away. If you don't write on the boxes, the state writes on them for you, using a list that has never met your family. 15 minutes with a pen. That's the whole defense. Next week, what actually happens when you can't pay a bill? Who can really take what, and how much of it is a bluff? Subscribe, because nobody's going to tell you this stuff either. Educational content only, not financial or legal advice.